Good afternoon, ladies and gentlemen. Suzanne Dibble here, data protection law expert, community raw and uncut from the back of a taxi. After my day of talking and taking part in panel discussions and giving a keynote at the GDPR summit in London, and as part of that, I had a very interesting conversation with a lady who was giving a number of talks in the in the marketing stream, if you like. They broke it down into like a general stream, marketing stream, and a HR stream. So she was a marketer, and I asked a question. It's always really fascinating when you see marketers giving talks about GDPR compliance, because they come at it from a completely different point of view from lawyers. And I'm not saying they're right and I'm wrong. I'm just saying they come at it from a completely different point of view, and they're quite happy to stand up there and to say to a room full of people categorically, you can't do this anymore, without giving that any kind of explanation or backing it up by the source material or pointing to the article of the regulations or whatever, or guidance, whatever. They just blanket say, yeah, you can't do that anymore. So I asked a question about Facebook marketing, and I said, so when I'm uploading my personal data into Facebook for the purposes of doing retargeting, then could my lawful ground of processing be legitimate interests? And the first thing the guy said was, why would you want to do Facebook retargeting? Isn't there a better way of marketing? And I was like, well, that wasn't my question. And actually, Facebook retargeting is doing very well for me. Thank you very much. He didn't actually, the guy who was doing the talk didn't actually know what on earth I was talking about. I think he was more of a traditional marketer. But there was a lady who kind of seemed to know what I was talking about, who again was quite categoric. She was kind of his sidekick. Quite categoric that for Facebook advertising you would need consent, a granular tick box specifically consenting to Facebook advertising. And was adamant about this and trotted off lots of provisions of regulations that I knew didn't apply, and etc. So I got a bit cross at this point, because what I really hate about it is when people who don't know the full picture, or even if they do, just categorically saying to people without understanding the ins and outs of what they do and without giving it a proper risk analysis, they say categorically to a room full of people, you can't do this anymore. And that gets me a little bit cross. But anyway, so this woman she said, well, I was at the privacy conference at such and such, and they were all saying that digital advertising is dead. And I was like, really? Really? Well, why hasn't Facebook's share price just completely collapsed then? She was like, well, it probably will do. So anyway, so she said to me, why don't you phone X? Now, X is a very well-respected privacy lawyer in the city who I know of. And I thought, and I was in a break, and I thought, do you know what? I'm going to phone X and find out his opinion. Okay, so I leave a message for X, thinking that he wouldn't get back to me at all, because like me, he's probably working till 2 a.m. every night, because I know he's got so many clients coming to him about complying with GDPR. Anyway, I leave him a message, and literally 3 minutes later, he phones me back. And a really nice chap. And I talk him through my scenario, and he says, you're absolutely right. Yes, I would say that is fine for legitimate interests. Okay. So firstly, I'm thinking, thank goodness I'm not going mad. The marketing woman hasn't, because she did look at me like I was a little bit crazy when I suggested that we might rely on legitimate interests. So I thought, good, I'm not actually crazy. And but he did make a really good point, actually, which is the point of this video, which is that aside from GDPR, at the moment, under PECR, the Privacy Electronic Communications Regulations, Facebook advertising and other display forms of advertising aren't covered by that. PECR only applies to email marketing, automated calling and text, and not things like Facebook advertising. However, he did remind me that under the draft wording of direct marketing, they are considering extending that to it's direct marketing that's either sent or presented to, which was designed to cover display advertising. So that's definitely something to watch and something that I'll be keeping an eye on in the group. But at the moment, pleased to say, he agreed with me that legitimate interest would be a lawful ground of processing. Now, he did make another good point as well, actually, which was that if people opt out of the email list, then ideally what you would do is opt them out of your Facebook retargeting as well. So how would you do that? Well, you obviously, when you upload your list to Facebook, you call it something, don't you? You name that custom audience, and you could give it a date. And then if, maybe you check that on a week, depending on the volume that you're processing, on a monthly or weekly basis, you would delete that previous custom list, and you would upload a new list of people that excluded the people who've opted out. Then that would be good practice to do that. So there you go. I thought I would bring you up to speed on that discussion. I know that when I did a video on, I think it was the marketing webinar that I did actually, there was a question because I talked through my view on legitimate interest for that, and then there was a chap that said surely we would need to get consent for that, and if you want to get consent, if you want to put it absolutely beyond doubt, then fine, put a tick box under your lead magnet or wherever you're collecting the data from, and put a tick box under there that has a separate tick box that says tick here if you agree to us marketing to you through Facebook, or retargeting you through Facebook. If that's you want to put it absolutely beyond doubt, then you do that. But for me personally, I will be relying on legitimate interests for doing that. I will probably listen to X's good advice about people who've opted out of my email list. Then I will regularly upload custom audiences that take account of those people who've opted out of the email marketing, and I'll certainly be keeping an eye on the changes to PECR and letting you know about that. But otherwise, I was quite relieved to know that top privacy, like the top privacy. I know you guys think that's me, but it's not. I'm just really good at translating it into language that you guys can understand generally. But yeah, it was good to know that top privacy lawyer agreed with me. So there you go. That is my video for today. A short and sweet one because I'm absolutely wiped out after an early start and going and speaking at this summit all day. But I know I've promised some certain videos. I'll be doing one on territorial scope, and I'll be doing another for you. I know the website designers and developers in the group have been having a great time sharing all your thoughts and expertise in this area, so I'll be doing a video for you too, and I've got a few more plans as well, so they are definitely on the agenda. But for now, I can't even speak anymore. For now, I will leave it there. Have a jolly good evening, and I'll see you tomorrow.